Hmm.
The paperwork is not completed. 3 times the so it's a very something. 52.
Hmm. What is the office note?
Office code says and you put directly to the part. You could not complete after.
Okay. In view of office note dated
15-5.
15/5/2023, list this matter after courts.
May please a lot.
Yes.
Madam, item number 53, madam, with the consent of the other side, madam.
Yes.
If they come up after vacation, then amicable settlement is possibly there, madam.
Okay. Mr. Abdullah, learning counsel for a petitioner, submits that talk for amicable settlement between the parties are going on. Accordingly, matter may be adjourned to enable to finalize the compromise system. Prayer is allowed. This matter after 4 weeks.
After the vacation.
After not be
Who the
after 4 weeks.
Interim order may continue.
Interim order passes.
Of that, madam. And item number 41, madam. There is no case there, madam.
Yes, any interim?
No interim, madam. 302.
Yes, when?
18 May.
18.
Of that, madam.
18 May 39.
25.
Of that, madam.
Yes. Item number 3 and 5. All are same case, 4, 6. So 3 and 5 got relief. People, okay, wait. You wait. This is item number 3. Can you wait for 5 minutes? Otherwise, you'll have to do item 4 and 6. These are same matter. Okay, let us see. Any interim? When Goswami?
Plus, that is on the 29th May.
29th interim to continue. Yes.
Your Lordship, item number 30. CD not available.
Any interim?
Same.
Same date interim. To continue. Yes.
Excellency for item number 50, Lordship. Line Rangers Council, Mr. I. Hadley, Secretary.
Hmm.
Not available. So, kindly pass on the measures for the day.
Have you taken consent from the other side? Okay. On the prayer of the learned counsel for the petitioner, matter stands adjourned for 4 weeks. List accordingly. Item 50.
I think
50. Yes, Goswami.
You want to withdraw.
Withdraw. You want to withdraw? Okay, withdraw this. Already granted bail. We'll do something in this regard. Filing application will both proceed. Dismiss and withdraw. Yes.
Next is item number 33 and 58. Kindly appreciate the following.
33,
33 CDSC, 38 CD dot
38. CD not received. 30. Any interim in 38? Interim to continue. 33. Wait. Any interim in 30? 33. Any interim?
33 no interim. 33 there is an interim.
CD is also here. You wait. Sorry, rejected.
38 there is an interim.
CD is here. Case is here. We cannot adjourn like this. Yes, next. Or we can do it, we will vacate the interim order. And it will be, take time, whatever you will.
Yes.
30th, which date?
Third of October.
3rd of October, interim to continue.
This was listed for the customer 31st. For the adjournment was offered and this was supposed to be listed in the application, but that this is not listed in your lordship has it is the level for the world.
Okay, now what is the matter about? It's a bail application, revision petition, criminal review, revision petition. You make a mention before a senior bench. Court number? Uh-huh. 9. Make a mention before court number. Yes, Maharaj.
May be the question, I think 39 lakh.
Item number 39.
Can I count tomorrow, my lord, with EB number 2708? 39.
CD is there,
PD is there.
along with
Tomorrow, EB 2708,
tomorrow list is already out.
Yes.
Item number
38,
38.
33.
So out of the same CD.
Same thing. 39.
Today's is 39
39.
and tomorrow's is 38,
33.
33. Okay. List is matter tomorrow on the prayer of the learned council for the petition.
EB
Not necessary, just make a mention that this should be taken up with this.
already, 100.
Any interim?
30.
Yes.
Just I was to mention item number 41.
40,
42.
42 years, Goswami.
PD not received.
Any interim?
Yes, interview.
When?
When on 4th of October.
4th of October.
Publishing. We have to mention for listing of 2 methods, we are adding out of 10 affairs. One
Bail.
is DA.
BA.
Alright. Item number 30. Case handling of all.
Act number 13 is associate.
Search it.
I want interim method.
Okay, you wait, let the matter.
Motion be item number 1.
Yes,
I need to page number 8.
fair page number.
Page number 8.
Why do you purchase gold from others? Huh? Why do you purchase gold, stolen gold? Melted the gold for what purpose? Will you take somebody coming and giving you gold, which cost 1 lakh, will get 50,000? Your intention is bad. Yes, to the satisfaction of? Goswami, to the satisfaction of?
I mean, allowing. My submission.
That is
For the CDL.
Yes, yes. To the satisfaction of
Satisfaction of.
Kamrup Metro. And tick mark all these names. I have asked Bijan Mahajan's client, then Munir, and this melting gold. Now we are giving you. Next, same offense, that's why I'm giving. We have granted 2 already. Bijan Mahajan. But we have asked the PP to note down your names. If you mail gold next time, we'll monitor and get the search sheet filed within 30 days.
Item 2.
Maybe that's it.
Huh?
Name.
No, sir, we have seen. It's a nexus between everybody is involved.
Item 3.
Huh? Who is in another court?
One of my friends was case. And he-
So was the FIR.
I would like to withdraw the litigation.
You want to withdraw? Because this is a case we are supposed to grant. This is a case to be granted. Okay. The learned counsel for the petition submits that because he has already been granted. It's a case of grant. Withdraw.
Item 4,
Item 4, arranging of action, already the point is that jail also. And for it,
Same FIR.
yes,
That you have withdrawn the same FIR. Just now the withdrawal, this is item 3, 4 and 3 and 5.
Yes.
You want to withdraw 3 and 5. Okay, 3 and 5 withdrawn. 4 is out of the same FIR.
yes.
You are inside for how many days? I-
11/7.
We have granted some, these people are that on the same FIR, we have granted some and not granted the original book. That was there. That person whose SIM was used to do
Yeah.
criminal activities, that we have not granted, but these are not like that.
One thing that clear indicates that
They have got, so that's why just now I said that, we will be strict. From next week, we will be strict and we'll ask the persons because, and we'll proceed under 195 for perjury. We'll proceed under 190. I'll ask Registrar General to lodge FIR that wrong affidavit has been filed, not FIR, that provision 195A. Statement. We'll do that. For today, it's for everybody. Just show us. Moment it is withdrawn, we'll ask to investigate why withdrawn, and you will have to give a statement. And if it is a case that you made a statement, no bail application is pending here and there, and we'll proceed under section 195 for commission of offense under 195. Yes. Allowed. Yes, item 4. Today's satisfaction of Moriba CGM.
item 5,
And this I have just observing for last 3-4 days. Yes, we come prepared, we read the files, why?
This is the reason for that.
Incorporated, that statement should be made. So today we are not taking any action, but from tomorrow onwards, we'll take.
item 6,
Same affair. Where is the affair?
Rejected this petition, I was because the plain rejection order dated 1/9/23.
Where is that?
Next, case number was 16 was this. So, but if I'm a customer of that SIM. I have under of the facts.
Call for the case there.
Earlier lawsuit has gone to case.
That's why I have rejected. So rejection will not give a day one. Yes, when ask him.
28 minutes.
How many days you are inside?
7 days.
On
28 minutes.
20. CD.
item 7,
None appears for the applicant. Applicant. Release this now matter after a week.
8,
Yes.
That's case number 14.
We'll call for the CD.
I am not the main communication already transmitted by the So this we can consider. So 89 is not applicable against me.
Who are you? What is your name? Jiabur. You are Mohibur. Main accused is Jiabur. Where is your forwarding report?
Case number
38.
33.
The Chalan or something like that or what? No. What is the where is the FIR?
Page 12. 14. 14.
Oh, fake currency, no?
Okay.
You want to see the fake currency.
But I have another scissor list on page 6 well, which was six from my
26. Keep it for a 26.
26 line. Okay, 55, of supplementary list.
You need you. 439. Who is the FIR?
Case number
15.
16. Another Mazul Islam.
You are?
Another Mazul Islam.
You are not name accused.
I'm naming it. And it comes to the after.
Nazrul Islam. I have not seen this file. What is the allegation? Let us see. Oh, that this is the case. That is Chalan. According to you, you are not aware, and some. How many days you are behind bar? Let have the we'll have the case then.
Case number 24.
Page 20, page 24.
Of the offenses. Except 470, 470 is punishment for life, but it is available.
No, you want to rely on the High Court notice.
All the offenses are up to punishment. I'm relying on this. No offenses were given.
Yes, what you say.
One. not
His
all-
case is that in the FIR also, he basically it is the person in somebody's, what is the name?
Alipur.
Alipur Rahman got it printed in some press, Azad printers. Is that it?
Yes,
Then it was taken, and according to him, he believed it to be the genuine. Then he went to the forest office, then only it was detected that it is fake.
So from the place of the file, made it the
The second,
giving inquiry from the state of
Second
Alipur
paragraph.
Lahmi. It was found that he had Mr. Ali.
That I have seen.
Yes, sir.
Yes, any further custodial, do you have raised?
I actually 13 days, my house was searched, nothing was recovered from the.
the problem, the 13 days is too late, because for the purpose of investigation.
That is not the issue, but the issue is that
Now, well,
Second is 24, number 24. Punishment up to 7 years.
that we understand, but sometimes those principles are, we know that is needs to be followed. But sometimes situation may as such that in emergency nature, it should be page 24.
15 months.
I have seen that.
470, 470 is available.
You are Mr. Nazrul Islam.
Yes, sir.
Thank you.
Okay, let him go. To the satisfaction of
Baksa.
CDM
Baksa.
Baksa.
Item number
Government
9.
should not spend much money on these people.
Motion AB item 9.
There are four number 3 is the level relationship.
You are calling sheet case diary.
Not on leadership there, my lord.
We are not giving any benefit to ladies. It's not a case for any interim.
My
See,
lord, Both the customer was discharged 4 years ago, my lord.
maybe.
Not,
This is a case, we are very liberal. When we don't give interim, some reasons are there.
my lord,
And we can reject the whole case itself today, no problem on that. Because it's 438, we'll say that it's not a case, case is made out. It's a privilege. Why should you call for the case there? Police will proceed, arrest you, then we'll see how many days you are inside. Tell us, which one you will prefer? Okay, case diary. One, 28.
my lord, 3 number 3 is only registration. So I am the.
Okay, it's called for the case diary, so it is submitted that the petitioner petitioner number 3 has already been arrested. Mr. That's something. And he may file appropriate application for regular bail.
Item 10,
It is interim within 10 days. When, madam? November. Let him enjoy the puja.
Then Lordship, 2nd of November.
2nd of November. Let us not make a jam before puja. Yes, wherever interim is there, I think it should go. Oh,
2nd November.
Change for you. This is a fun-
holidays are changed
on
up to
7th.
7th November.
This will be
It's better.
11,
better.
It was a mistake while vacation was before puja. Yes. Yes, 9.
FIR is filed. Registered under the 326 number, but the person, the petitioner who was riding a motorcycle method and the active LSBT or blocked the road by parking his bike method, and there are some altercation between the two cars, and there are some push and pull method, and this FIR was lost. Nothing was happening to 326 meters of time.
Seems like also, that's why we made a question mark whether to grant interim or not. Seems like that there are some fight because we'll have an we grant an interim here. What do you say? Let him have his statement. If injury is there, we'll reject it. We'll not hesitate. CD interim, CD along with the injury report, if any. I do not think there will be injury report, if any, on
On 7
7,
11.
7/11, within 10 days record statement.
for motion item 12,
Yes, yes, any report?
Report, Lordship, I will inquire.
Okay, Mr. Borthakur was, I think, Borthakur was there on last occasion. Okay, we'll list it,
After something.
okay. I think Borthakur was there for this. As I recall, I don't know.
bail hearing BA item 13,
Yes, okay.
I have already looked
Sir, what are the offenses?
44849.
Just, madam, just search sheet number.
Lordship number. Case number Lordship 230,
Hmm.
oblique 23, dated 31/7/23.
And do you get the sections under what?
Sometimes they give Lordship, but in the.
That's-
They not giving the-
Don't give me. Okay. Two things are necessary. Whether this person is,
Section given, Lordship, under section 448, 493, I think.
494, these are my magistrate tribal. Magistrate tribal, so I to do not committal court, trial court. This is a BA. Oh, that case, special case, you have granted BA. The interim order passenger shall continue till he files a fresh bail application before the trial, learned trial court. And trial court shall consider the same on its own merit.
14,
AB no, interim. Interim. Scan copy of the record, not received. When the scan copy of LCR called by this court under its order dated 25/8/2023 has not been received. No office notice also not received. Registry to issue reminder in as much as the registry issue reminder in as much as the present litigation involves a citizen's liberty. List on.
So we hold it, sir.
It should be 2 months.
After 2 weeks.
After 2 weeks, please give a date. We'll give a fixed date.
28,
20.
9.
28/9.
16,
Yes. What did you do?
And postmaster of Pushpavish.
Oh,
I am.
you are the main man. You sent this peon. He thought that this is necessary and got all the signatures.
Earlier was it because Malo gave to this is the money roti,
Mm.
and it was encouraged the Malo in the rate of room.
Mm.
And the Malo after the people still it was put the Malo still and it was given to the person council. But that was not printed.
In the account, ultimately, this is not.
Behind my desk. I am from 66 districts.
Be there. You are rejecting it. Public money. File such it. No, we are rejecting this. These people, hard-earned money are being deposited. They have a faith on the officers in post office, and you do all this. This is not a case for them. You be there. Peon, you have sent.
Both the person.
Hmm. The peon was your messenger, and these old people, they do not know. Say these signatures are required. No, this is not a case. Rejected. Rejected.
17,
In some cases, whatsoever the period of detention, we are not clear. Yes, Mr. Das,
17 case there is no issue.
where is the affair? This is BA or AB?
One case was taken up by public matter.
Those you are also a conscious public to beat up others. Be there.
That person already granted bail in the lower court.
They might not have.
Case 13 matter.
You also go to their lower court will allow you to withdraw this. Where is the affair?
It has case 13 matter.
No, this is not a case of bail without city.
Yes, madam.
It's pathetic. Somebody will, after having dinner, will go outside. You will suspect him to be something either thief or what we call hopadhara and kill the person. This is not done.
25/9.
Yes.
Public.
18,
Yes. Yes. Where is the affair? Yes. Particular. Original. So where is it? Yes. 10.
petitioner is arrested in Panjari case, and he was given police custody for 5 days.
Oh, that shooting incident.
Yes, madam.
He tried to play near some Birubari.
Yes. Conduct is not good, madam.
Hmm?
He is trying to.
He was trying to escape. How can you grant you bail?
How the this person is somehow.
He resorted to firing.
What is your guess? What is your guess? The police made encounter. Or what? How many days?
43 days, but only on 9.
40 days. So 43 days in other cases.
Other case. Now in 9-8.
34 days in this case.
What was the allegation against him? Earlier allegation?
Earlier, it is, I am the pastor of the mobile.
Hope you will not purchase mobile like this. Okay, to the satisfaction of
CDM sound in
Metro.
19,
He had enough from bullet to
Yes.
custody. He had enough. Why? What is this? City is there?
19 is there, madam.
Oh, there is an objector.
19 is there.
Nalbari case.
Nobody can-
Nalbari case. What is this?
Malo,
Let him go.
no, Malo, I am from objection notice.
Why?
Because this girl, Malo, she was promised to marry notice.
Yes. Promised to marry. They got married.
Not married, then notice she was used notice physically. And my lord, for registration of them, it was applied.
Okay, let him come. Let him come.
bail hearing, item 21,
We'll see the case diary, then we'll decide. Item,
21,
21.
where is the affair?
AB,
AB, Yes.
This artist submitted.
charge sheet submitted. Your name is Alaluddin, accused number 4, huh? Alaluddin. Interim. Submitted under any section? Sessions Tribunal or Magistrate? What is the offense? Offense?
Offenses, my lord,
30. That definitely 30 will be committed. CS being
The artist number 29/2022,
Hmm.
dated 17/5/2020.
22,
till committal court takes up the trial court takes up the matter, will be on interim, and the court will decide whether it should be granted bail. Or
In the meantime, another point is already being activated by this one.
that I think is something maybe now we have little bit changed it. We should not make it absolute. We have the power, but we are just giving a
I'm obliged.
because many things are there. He may give new conditions, bail bonds and all, everything is there. Because earlier interim was before the police. There is no question of arrest by police. Now judge will exercise his power.
I'm
Yes.
obliged. I'm obliged.
Yes, next.
22,
438. Where is the FIR? Who are you? You are Sunil Das. FIR is at page 13.
That is the fire where I did.
It is accidental murder.
It was an accident. The two persons were Subhajit Chaudhary and Vikunda.
Oh.
Now, both the accused persons, both the part of this injured is a accidental injury.
Oh.
Now, the local people notice they had, after the incident, notice they had accepted Subhajit, my lord, Chaudhary.
So there was an accident. Subhajyoti hit these two people.
Subhajit and Vikunda. And both the persons, they sustained injury.
In the bike.
That are the local people notice they had assaulted Subhajit Chaudhary. For which notice he died.
Was this man also
Yes.
he was also
They are not implicating evidence also.
this mob beating people, we are not inclined to grant anticipated,
And you are not taken to the hospital, but the other person was taken to the hospital.
rejected. Rejected. This is not your job. That somebody will meet with an accident and he will beat them up and leave those people in the road. Somebody's son, it's not a case of anticipated evil, rejected.
Item 23,
Yes. Mm.
Who is the video on the last occasion, my lord? It was sent for after the case.
Okay, so with postmortem, 302 or what? Uh-huh. Interim bail granted 302. Okay, enjoyed it.
Third of October.
3rd of October, interim.
24,
Yes, when
29/9.
29/9, interim to continue.
25,
Yes, Ahmed, what is this? Page 12, when
Talukbari clear, 22nd.
22nd, interim to continue.
26 and 27,
Yes, Mahajan. Yes. Mm. What is the allegation? You are Monita Das. I heard. What did you do?
I was not there at the event time. Allegation is that certain names were deleted from the list, and others got the benefit of the scheme.
It is there.
Madam,
What is her role as video?
our role also, he is also admitted also, he has not made any field verification. He relied on the person of the Gao Panchayat and Deputy Secretary, on the basis of which notice this Bharat Khan was released to the other beneficiary, which are all fact.
And what about the other
Other person
who was this part of Pradeep?
After putting was, accountant.
Huh?
Accountant. After putting was accountant.
Okay. Then part of thing was accountant. Then who was Sofiul? Sofiul.
So fuel was not educated engineer.
Okay. Then Rokibul.
Rocky Bull.
Hmm.
Rocky Bull was not Gao Panchayat coordinator.
Allah, even
he has declared the
statement is recorded. Okay.
other person was right from.
With that other part. Okay, we'll come to that. So far relating to this video, Monita Das Raha, interim made absolute. Huh? In view of the materials available on record, and also of the fact that she had cooperated with the investigating authority. Now, who is this Gulzar Hussain? You are the main person.
He is the main person.
You know that.
You love to see whether the provision of the Assam Panchayat Act, section 4 में.
Give us. In India, there is no dart of act. The problem is that all violation. In terms of the act, you will say that this is not me, the Gao Panchayat, there will be a Panchayat meeting, is that it? Then Panchayat will decide who will be the beneficiary. Then only on the basis of that decision, Panchayat passes the resolution accordingly is given. And at the end of the day, you will see there is no house, there is nothing. Yes, Shiksha?
Civil format. Now this or limited to the Gao Sabha for
That's what I am saying. Gao Sabha will decide.
my. There are some persons who already died. For them, was the bank accounts was created and this money was transferred to those accounts.
Let me see the CD, then we will decide.
But this is 22 of my.
Okay, yes. You are Guljar. And what is the next item? Only two items. Okay. Hmm.
In terms of this, the president resolution, you have considered finance case basically. Some names were deleted by the
What is the FI?
which is the company which was brought before the
Yes.
page 13. I'm not saying that. Page 13. Seven names were named as the appeal minutes, including the PDO.
Yes.
This 30 million resolution taken by the council. The scheme which was earlier known as PM payment, now it is our time. Particularly some persons, they get limited under this old scheme. Now they were included in the list. Therefore, some names they were deleted from the list. They will be taken at this
That we have seen, that since earlier they have got, so that is cancelled.
that is the reason.
So according to you, that has been the reason. What is the investigation?
Well, I have appeared twice in this next appeal. And then there is a provision, they have finally reached it also, in that it is the language, the volume of the very much. I repeat my thing.
But Gulzar Hussain, Budhan Bhagavati has already been granted bail. So these three you have not implicated. Police has not, these three and Mr. Mahajan's client, you have not specifically implicated. But this person, Gulzar Hussain, one Budhan Bhagavati and Habibur Rahman.
I included even about other some of them are government person, they were arrested, later on granted bail.
These were later are granted bail. Arrested and granted bail. You don't have any case.
I can see that I have a bit my statement has been recorded.
That is not sufficient.
And that simultaneously they have filed a case for the same allegation.
Maybe, because two different things. One is their right under some scheme formulated by government is violated. They are seeking redress in a writ court. And other is that you people, you, Gulzar Hussain, Budhan Bhagavati and Habibur Rahman. There is no village that has been wiped away by river Brahmaputra. No houses, no people, some dead people, you have allotted everything. And you, according to the CD, you are the three, Gulzar, Budhan and Habibur. Budhan and Habibur already arrested, released on bail. You also go there and come back to us. Yes.
That lane they were existed in the earlier 2016 listing. And then the phrase was there. The name change said subsequently another this person. In the meantime, that blazer was up. Now that this remain in the common. Approximately 300% they were elected under that system. That this was in the year 2016. I admit that the blazer was up. But that this was of 2016.
That's all. However, perusal of the case diary reveals that the present petitioner, one Budhan Bhagavati, one Habibur Rahman, are the prime accused in misappropriation of government money, misappropriation and embezzlement of government money. And there are some other prime accused, namely Ambika Khatun, Safikul, Abdul Jalil, and Noor Jamal, are yet to be arrested, and they are evading arrest. Full stop. The material so far collected implicates the present petitioner, along with Said Buden, Bhagawati, Habibur Rahman, and Habibur Rahman. Considering the specific allegations and role of the present petitioner, and also of the fact that investigation is at early stage, this court is of the view that present petitioner is not entitled for a grant of privilege of free arrest bail, being a public representative. Accordingly, the present bail application stands, AB stands rejected. Earlier interim order stands vacated. Case diary be recommended.
28,
Then by the earlier.
No,
It was a 15-minute time.
We know.
Only after 18 minutes.
they are very cautious dealing with public money and public representative. Yes,
Okay.
next case.
28,
Next period, Your Honor. This citizen under Section 46, basis for the petitioner minor.
Mm,
He was entered since 9/6/2016. No any condition has been violated during that period. And appear before the Indian engine, appear before the investigating officer.
Case diary not received.
case diary with injury report. Huh? When? After puja.
Interim in the
Of course. You enjoy the puja.
After Puja, then
9th, 7th, 11th, 7/11. 7/11, good day. Interim order passed.
item 29,
case diary not received.
An interim?
and
Okay. Give it
7/11.
7/11. Interim to continue.
31 and 32,
City receive?
Case diary not
Where is the FR?
What happened, my case, the person expired.
Okay.
My NGO.
You are D. Dixon. D. Dixon. D. Dixon entry. Yes.
He runs an NGO, madam, and on their day, madam, there was also a matter. Quarrel between them, madam, regarding the matter.
That we have seen either suicide or they are tied up inside the room, no way out. In search of drug, they will shout, they will bind them. And how this person died?
He died. Actually, he was already in a dying condition while he was lying in a park, and he was picked up by the police and handed over to our NGO.
Okay.
On that night, he was expired.
So overdose. Overdose.
No, madam, overdose.
What is their role?
And-
Police, you have given them the dead body.
Madam, he has received this person, madam, and if there is so much, he in his statement says that he has injured condition, but he has not taken.
No, okay, he has committed a mistake. What action will take against the police? Why police has, instead of taking it to hospital, taken him to a hospital? Now let us explain. Who are you? Or take your seat. Tell us. We'll have an CBI inquiry from today onwards regarding this. Why is it your responsibility to hand it over to an NGO?
Cannot be.
What was your responsibility? We'll see later on whether he can be de-addicted. Your first responsibility to take him to the hospital. And he might have committed a mistake by accepting that. But you are police, mighty police.
It is his person, madam.
Okay.
There are injuries,
Page 18 is the matter of analysis. Page 18.
This is AB, any interim.
In time on interim, madam.
You have recorded your statement. Why we need your custodiality? Is it not, do you say it is a 302?
Because the, so far PM report is concerned, madam, several individuals are.
Okay, do you say that this is a 302? If 302, what was the motive in the city that they have killed? Absolutely.
Two cases are there.
Okay. So and so Mr. L.R. Mozumdar has assisted the public prosecutor in seriously objecting the bail appeals.
Then my objection,
Yes, your objection is always there.
31 and 32.
Yes, both. On that day happened, a good thing was that there was a CCTV. There was a CCTV, he was a whole drug addict, his hands were tied because they could not control. Then the owner was arrested, he was for jail almost for 45 days
It depends.
in a different case. You are not there, Mr. Bobo.
Type of cases are there.
Yes, some,
Yes. Just get the.
33.
You need the addiction care. At the same time, they are also taking risks, all these are risks. Moment he will not get his dose, he will behave like that. He may cut himself, he may die. Yes, next.
I'm on interim also. The fact is that what is the main accused, prime accused is the son of this present petitioner. Okay? And in FIR, though I am named in the FIR.
It is succeeded.
No.
No, madam.
Okay.
Though it is.
Where is the FIR killer?
FIR case,
Page,
multiple kind of case came up.
what is this judgment? Why have you annexed
No,
judgment?
because whatever initially the deceased person, the father of the informant,
Hmm.
he gave the FIR against my son. And
Okay.
for that he had got for conviction losses. As soon as he came out from the jail losses, he have taken the right.
Okay. What was the earlier allegation against?
Same allegation of it, that he did the assault and all that. But kind of for 6 months we didn't know. And after coming out from the jail, he done this stuff. Then more.
He has not preferred appeal.
No. Then he filed for the.
So there is a scuffle between two parties.
Yes.
One got convicted, he went to jail, came back and lodged an FIR relating to the earlier incident or new incident.
No, madam. He was convicted on the testimony of the deceased person.
Okay.
Deceased. After he came out and their bodyguard.
And he is the informant. Now his son has given the FIR against me regarding that case. And the present petitioner also, though he is named in the FIR, but in the contention of the FIR, there is no allegation.
Where is that FIR? Page 10.
FIR case 10. I am named in the FIR.
Where is the vernacle?
And it will also be found on page 15.
So, who died? The witness died.
No.
Yes,
His
madam.
father.
The witness,
Earlier,
earlier witness died, who deposed against this man,
no,
not this man.
son.
My
Okay.
son was.
Okay, your son got convicted on the testimony of the deceased. Now, after coming from the jail, according to him, that the witness has been killed by you and your son and with some other. What is the material against him?
So far materials are concerned, his son is the prime accused man. He has.
He has assaulted. any of
His instigation party is there against him.
how can you grant anticipatory way? Tell us, let us understand. If this happens, that somebody gives an evidence against the person and he is killed, and the killers are being granted bail, and had it been a case that you are not related to the victim, they're related to the accused, and specific allegation is that the group of people
No,
in the affair.
yes.
Earlier FIR is different.
No, that page 10. Page 10 FIR is the present case.
Okay.
Present case. If we go to the vernacular, specific allegation is there. Podokia Gone.
Particular one and two, it is number one.
Who is accused number 2?
I'm myself.
You are. So, পূৰ্বৰ পদকীয়া গণে নামঘৰত চাকি বন্তি জ্বলাবলৈ যোৱাত উপৰোক্ত পদকীয়া গণে পূৰ্বৰ আফেজত পৰিকল্পিতভাৱে, so a conspiracy and common intention and all are there, পিতৃক হত্যা কৰিব উদ্দেশ্যে ৰাস্তাৰ কাষৰ বাহনীৰ তলত জোপ লৈ থাকি মোৰ পিতৃক নামঘৰৰ পৰা নিজ ঘৰত আহি থকা অৱস্থাত পদকীয়া গণৰ পদূলিৰ সন্মুখত ৰাস্তাৰ ওপৰত আগুচি ধৰে আৰু 1 নম্বৰ পদকীয়াৰ হাতত থকা দীঘলীয়া নালৰ ডগা নাৰে ঘপিয়াই মোৰ পিতৃক, you are also present. Can you be stopped? 302, had it been a case that you are no way related, then yes, we would have.
I'll leave it
But
to the process.
You are part of that. His son is arrested.
Sunny there. Just before this.
So any eyewitness?
Eyewitness of assaulting.
Not there. Anybody who saw him also with his son? What is his age?
One.
What is your age?
74. That was the ground.
Where is the material available? and-
Judicial confession with the last.
Where is the case that he produced? Also, where is the statement given by the deceased before his death? The said deceased has not specifically implicated the present petitioner, as well as the statement of the victim, statement of the prime accused also reflects that the present petitioner was not part of the alleged offense. In considering the above, this court is of the view that no custodial detention of the petitioner shall be required in the present case. Accordingly, the interim order passed earlier is made absolute, subject to the following conditions. No?
Awesome.
He was not here. They are
It's not there, but I think we're there. Also, would like to take up, I think 19 and.
if other side is there, you can take up. How many letters are there? Huh? Okay, city is there. Let us take up this. If there is. Yes, Burwa, why are you seriously objecting in this case? Tell us.
Malo, they were first introduced to Facebook. Then it was socially arranged marriage. Then he refused to very hard because delay thereafter month by month. Then they applied for court marriage, but he has refused to register the marriage. And with the pretext that we have applied for court marriage, because they had physical relationship couple of times. This is the first clear case of
420. 420.
420 and 373 because at a letter only. And then now let's say there are some material yet to be examined. Why am I objecting? The person is behind the custody. But there are some they are yet to be examined. Get that litigation at least one of
May I submit one thing, Lord, with the context to the CP's submission. Lord. What is case is between two individual losses? If vital witness is the informant herself, Lord, on 161, 164 will go carry on the trial. Lord. The other person may not be related, Lord. How other person can vital loss? It is all evident.
The problem is this, you are a responsible government servant,
Possible kindly see the.
is not it?
There is no.
That is where this court is also authorizing most of the cases we are almost determined until unless you can change us. But in this case, a little bit of hesitation is from this court also. You are an officer. She is a young lady. Definitely, government. What do you do? SDO, ACS officer or revenue service. Definitely, a young lady, a family will expect you'll have everything, and on that pretext, you will have physical relation with her, and finally, you will not marry her.
That is the reason of you are supposed to marry her. What is the contact law? The case has been filed against me. That is, I have put behind that file law.
But there are specific allegation because on the CDO, we have perused the CD on last occasion also because it was adjourned somehow or because he wanted to observe.
Why he has come? He has come for objection with the
Main person is behind a file.
Keep me the case diary.
Detailing part is immaterial because he is not.
How many days you are inside?
24 days. As a government
At this stage
employee,
also I am objecting.
objection might not come because all this part has been already over logic. He is a reputed person, he will not exponent face the trial. And see, they have engaged, she has engaged the another advocate also for.
Now, the Supreme Court is saying that not only on merit, you also see the social impact. Earlier, we were of the view that what is social impact? We'll go by the merit.
This thing will never continue logic because we had an objective by engaging another lawyer when the.
He is assisting me. He is not making any submission.
See the motive for behind her logic that she wants me to put it that some that has been developed between both of them logic and they decided not to marry logic here.
See, her statements are specific that you have a bad intention from the initial date of inception.
That logic.
That was made out.
They should not, she should not have agreed to my proposal logic. He earlier said the demanding.
Because you are a cheater, that's why she believed you.
No, logic, kindly come to the
He
FIR.
took money also from hard work.
Logic, kindly come to the FIR logic.
He was seated from all the sides.
Kindly come to the FIR logic.
How many days? How many days? Tell us.
24 days logic.
Only.
Sufficient logic.
I am objecting at least there because there are some investigation. yet to
And
be
he's an officer.
No investigation.
You cannot say no. That will have to go by the PP, not by you.
No, no, kindly see, it is two individuals. Her statement was 161 and 64 will.
A rep is also between two persons.
No, that
Isn't it?
No, he is causing some 302 case in a street place, market place, which are taken fighting witnesses, are they are lodged, they have to be investigated lodged. The entire trial will go on basis of the 164 and 164 of the lodged victim. She is affected only lodged, not the society at large lodged, not the other person lodged. That lodged, their fighting witnesses will be there, eyewitnesses will be there lodged. It is not like, even other witnesses say that nothing was happened, even though court will carry on the wages on the 164 and 161 of the victim. That will prove the entire trial. Entire case.
You had an enjoyment with her during stay at Nalbari. The moment you were transferred, you thought, that, okay, fine, forget her. What I have got is my gain. Now you are gaining inside. Say,
This is not a case logic for marriage.
There is a logic.
This should also be competent for me logic later.
just a minute, just a minute.
But I think you're open. Out of data, again, it's out.
Okay, we'll pass this order. We'll see. We'll think about it.
That day nothing was.
We'll think over it. This is a case, just I'll have to apply my mind.
that day
Two aspect is there. See, you will get nothing keeping him inside.
Yeah.
From the case that it is seen, that almost from driver to the police, everybody's statement is recorded.
Yes, madam.
But you want to arrest some other person.
Some other person is, some
Means-
litigation is pending.
No, no, no,
And
no.
secondly, notice Supreme Court, in the recent judgment notice, Supreme Court has said notice, if the somebody notice indulges physical relationship with the first police to married.
Yes, that
amount to
is true. That is clear. That is clear.
That is
That is-
like, it attack the 676.
What the honorable session just finding logic. I should not say that logic, they finding the bail order, they have said there is no material like a feasible. And logic by everything just be, and that day logic was pleased to grant the bail logic, not ever pass the order. That time TV was not updating, but today you know what happened to sitting logic is updating.
No, don't say that. Don't say that. It is, Mr. Borua is always reasonable. Don't put star on anybody. We do not appreciate this. He has been engaged. You might also come be on one day here. These are non-issues. And this will not influence our mind.
No, no, that
I'll go through, from on beginning I have said you that I have a little bit of doubt in my mind.
but that day.
So we have heard you. Now will that this expression was sudden, like other days. Now after going through the CD, I'm reading, but at the same time, I'm also considering this. That what is the benefit of keeping these people inside? This is one aspect. Other aspect, if his conduct will amount, whether it will amount to 376. His specific his status in the society. Now, number two, there is specific allegation that he claims that he is a man from the Honorable Chief Minister's constituency, therefore he has some power. But that power is gone because police has already arrested him.
One thing is that he's not.
Okay, let me think over it. We'll get the order uploaded in the evening.
No, it is not one more thing. It is not, he is not a habitual offender that if he come out of jail, he will commit the same offense. He is not a-
That there is no guarantee.
No, no, it is-
There is no guarantee because again the allegation is that immediately coming from
That can be-
Nalbari, you have already started another relation with another girl. That is on the CD.
Suspended and nothing that his reputation already gone nothing for that. That thing is not committed again. No, no, no. He's not a theft or a habitual offender.
We'll see.
Law-
We'll see.
This says also I'm operating on that.
It is very-
So today is only 24 days.
We'll see. I'll apply my mind in the second half. I'm keeping the case there.
Another case was there, I think, 20. Just whatever motive, 218 completed 5 vehicles were listed before your honorable court on 7/9. And logic was pleased to grant the bail on motion is and this case came on another bench, same day. That time, logic, when matter was called, the order was not online. This is the order. I think 1990.
How many days? How many days? 25/7,
24 days, sir. 24 days.
not 20. CD is there.
In the case there is not.
But that prime vehicle was granted bail on motion. That is the problem, okay, they have known that prime vehicle has got bailed up, they're troubling us. Same forward. There is the
Dispose of. 8 to side level.
much of the, much.
35.
Mr. Borua, do you have that citation? Recent judgment.
I'm trying to find out.
If find out if possible.
On the Sarsi submitted was 35.
Source find submitted. Being
One of these Sarsi number was 291, 2023, dated 31/9/2023.
Sessions tribal or magistrate? Session tribal. Interim to continue till then, till you file. Huh? Sessions tribal, so committal, question of committal will come, till committal.
So there is some mistake in the date also. 31/9 cannot be possible.
31, it will be 8.
31 is the
8,
date.
8. You have a instruction over telephone if possible and inform us, just mark it.
36.
Or don't give the date, bring search sheet number. 30,
36 after submitted.
same, sessions tribal or magistrate? So 3 sessions tribal.
Article number 241, public 2023, dated 31/7/2023.
Mr. Chaudhuri. Mr. Chaudhuri. Huh? We'll just hear a phrase that tomorrow that has come. You come prepared, just let me express my mind. Just to clarify. First issue is that certain things are proved beyond any reasonable doubt that the man was found inside the bathroom of the accused. He was found in a tight condition, both hand and legs, with the water pipe. There were burned injuries. Das was also there. Who was? Bhattakur was there. Then there were burned injuries. Now, these are established. But now question is who? Who has committed the offense? So far coming to the FIR, FIR says that it is you. Okay? And FIR was lodged by the brother. Now, brother says after 3 days, he was unconscious, or after 3 days only, his brother says that it is you who did it. Now, FIR was lodged on next date. And according to the informant, he was not aware till 3rd day when his brother informed him. So therefore, there is cross-examination on the FIR. In FIR, he said, yes, FIR was written by police and I signed it. So that he was not aware how that you are involved, and he was not intimated by brother on that day is established by your cross-examination. That yes, police has written it, I am not aware. Now, police investigating officer says that immediately the person says that it is you who have committed all the things before the IO. Because the incident so happened, IO was informed by the officer in charge that go there and there is something has happened. So whether this statement before the IO, the allegation in the FIR, including alleging you only, and the statement of the brother can be treated as an evidence under section 6 of the Evidence Act. Number 1, raise that say. Under 6. 6 or what I forgot, I think under 6. Second issue is whether section 106 of Evidence Act is required to be applied in this case. Because it was established beyond reasonable doubt the seizure. One seizure witness says that some discrepancies is in, but others specifically said how and where this was recovered. The 2 attendant in hospital, they said how, in what burn condition, and they also corroborated the plastic rope. So these were established. Now then, whether only the accused statement that I have not seen actually who has done it because of the light will absolve you from that, or whether you had any responsibility to explain the position, how and why, what was the circumstances that you was found in this. 106 and whether section 6. This is disturbing, so we are giving to be spoken up while dictating. So let us have an elaborate hearing. So don't think that I am asking some question, it will be a hearing. Yes, next case. No,
37,
yes,
Party submitted.
charge sheet submitted. Sessions tribal. Charge sheet being,
Our target number was 290/2023,
Mm.
dated 30/6/2023. No, it is the second level, 270.
session tribal 376.
I want it.
Okay, till you appear before the sessions court and file application.
Right.
item 40,
None appears for the petitioner on call. Oh no, there are some scan copies. What is this? The scan copy call for is also received. None appears for a petitioner on call. List after 3 weeks.
43,
Yes,
Not a case, there is no picture.
interim is there.
Yes, it is there.
Interim to complete when?
8/11.
44,
There is there, right?
Yes. Mandal, what is this?
Yes.
Can also be fine or the other act is not clear.
Mr. Das, you also inform Mr. Bothakur tomorrow's case.
No.
This is the idea. Here what happened about you will know.
No,
You will know. Where is bed 11?
yes, it is.
Yes, that's consenting or actual.
As per what's the
Measure. Age is also, as per FR also 6 to 8 years. But it's a consenting or forceful, as he says. She went to have kurkuri, she was kidnapped from the shop. What is the relation, your relation with the girl? No relation.
Because he is the leading man of the family.
Hmm. You lead from the jail. Submit. No case.
Now,
You don't have any case.
now, affair, what sir says, there is a lot of granted case against the petitioner. Because the history of the affair was seen. Now he went to the shop to purchase something. And therefore, he because of disputes regarding the land of the plot of land, particular land, is related to the masjid
Hmm.
and the employment. In that meeting, the ending man, we raised the objection.
Hmm.
Because of that, this project has to be solved.
You are summarily
Correct.
considering the specific allegation made by the accused victim in her statement recorded under section 164 as well as under section 161. This court is of the view that this is not a fit case for grant of
That's a lot. Consider in that medical report.
accordingly the same stance rejected. Seize your niece.
Medical report is.
Seize your niece.
But medical
Seize
report,
your niece. She believed you.
my information, medical report is negative.
May be negative, may not be
How does he know whether there
Yeah,
is no available?
not available, may not be penetration, but the statement she has, if she gives this statement before the court, no other evidence is required. No other, if she remains constant, the way she has described. And you say no relation, you are her uncle. Yes, next case.
45,
Where that case, my lord, where the last line was there, that you in agenda for.
Thus, can you consider interim? First day we did not consider interim because it's a from Nunmat or something like that. Here only thing is that others are consenting measure. Only we did not give him a bail for the last line of the affair at page 11. Make photos viral, etc.
That he has not agenda photograph.
Okay. CD call is not received. Considering that, considering the nature of allegation, as well as the fact that interim was not granted, expecting that case diary will be produced on the next day itself. This court is of the view that the petitioner is entitled for pre-arrest bail. You will get your statement recorded or anything, any photos or whatsoever, then we will cancel.
15 November.
Yes, 15 November, we will get your statement recorded. Hmm? Yeah, that's it.
46,
Was there a call for is not received? Their case is there. You You are Shahjahan or Mizanur?
Indication of mixing of the flood relief.
Oh, that case. Bring the circuit. That is, they have
All have said, they have not.
received anything.
Distributed the rice.
Hmm.
etc. Only 1.5 kg, somebody has got only 1.5 kilo.
But government has given huge amount.
No.
No.
We have,
So RTI,
petitioner number one has received the material. And it was delivered to the village complaint, village committee will distribute the only thing, it is nothing now. Here,
Is it not your responsibility that is distributed?
but I not distributed.
Is it not your responsibility to look into, even if
In my last month, there is village committee.
Hmm.
It is formed by the village. And the article.
what you heard about the distribution process?
one of the things you. Others are also. Specific irrigation is similar. They were distributing.
You are Shahjahan
These will ground.
and Mizanur.
Generally, to what number, Shahjahan is the Gahua. So there is a clear between the Shahjahan and the informant, the idea. For selection of the Gahua. In them, there are enmity between them. And the apparent laws after a year.
And allegation is that the.
Exactly, that-
Sold out now, these things have to be recovered. When
No,
they have-
sold out. Forget about the sold out. The FIR itself says that there is no receipt by anybody, and the witness says
The intent
that
of this-
says,
But
and specifically names you who distributed.
at that time, what is there, how it can be done? All right.
Rejected. The villagers statement. Villagers flood victim statement clearly reveals that these two petitioners were involved in misappropriation of the relief materials meant for the flood victims. So considering.
But the beneficiary does not say anything, but again.
Say, everybody said, pinpointedly both of yours name.
I think 56 of supplementary list.
But Mr. Das, we do not know, all this will come back. All this will
Yeah.
bounce back again if you take bench 3, bench 4 or bench 2. Better not to reject and let everybody go. Everybody, all this clean ball will come bounce back.
Will have enough, set of civil-
Yes, all will come back.
Yes, right. Meeting bounce back.
Yes, FIR is 14. Yes. Two, we do not know how much matters. Two will take hearing matters. Two will take hearing matters.
I point out the matter regarding text, how he died.
Yes.
The case-
Who that kidnapok বিষাক্ত দ্রব্য হেবন?
Yes, the FSN has come, madam.
Hmm.
It is a positive test for organ transport for husband.
Hmm.
And the circumstances which lead to this is that, madam, he stood as a guarantor, madam, deceased.
Hmm.
And this petitioner took loan.
Hmm.
And after that, he defaulted in payment and the notice went to that guarantor. By 2020, there is a interest rate of 20 lakhs a home. And perhaps that is the reason why.
Too weak a person.
No. They will only be regularly paying the loan amount towards the EMI. During the lockdown period, he was not able to pay the same.
Your friend is weak-hearted. Allow. Any interim? Cooperated and considering the materials so far collected. No further custodial details.
This was a
Yeah, this one, this.
Interim made absolute.
On the-
Or you want rejection?
He was adjourned.
You want adjournment?
No, no.
Okay, we'll adjourn him.
If he allows-
Before this court, no special counsel is required. Organizer should hear. Admission में, class में exam. Yes,
Made the last time, so I have seen the past 21.
yes.
40 last time.
What happened to 40?
Now, in this particular time, have a look at the yes, yes, yes.
We'll not look at the affair. We have passed this order, we just add.
Not that, no, not that. And later is for
Okay, give the file, give the file,
14 months.
give the file.
It is came with LCR manner.
Hmm.
And understand Bora had gone to the but he some.
Okay, at two we'll take up at two. Huh? Ask,
For orders. Standing item number 12 for motion.
Well, manner, I request sometime manner and contacted manner. That is can on Friday.
Friday. As agreed to by the learned council for the parties, release this matter on Friday, 15.
For orders item 47.
Not found. And you know, we have also taken step upon the second and the third respondent. Into the electoral services. So my question is that.
Okay, list this matter after 3 weeks. Await service report. Await service report, list this matter after 3 weeks. Interim order pass by the second.
48.
Yes, Garodia, what is this? Okay, await service report and list this matter after 4 weeks. Interim order pass by the second.
Item 49.
What are
So
these
your
orders?
worship creation, my lord. He has some copy to private, trustee, he has received on first of September, your lordship. Yes, sir. And we have filed affidavit to that effect. And then I my consideration of the
What is that affidavit?
affidavit is filed yesterday, your lordship.
Okay, let us take up this matter on Friday. Let us see. Since affidavit has not come, she may come also. It is submitted by Mr. Goyal that in terms of order dated 11/8/2023, the justice service has been taken and affidavit has also been filed. The said affidavit is not on record. Registry to take the affidavit and release this matter on 15th. The interim order shall be considered on that, because earlier there was an order.
For hearing item number 51.
51 is on the state appeal, it was, GP Google,
We'll dismiss it
I asked my lord,
at 2.
I am not taking much time. Let it be,
2010.
Yes,
Go through the record. We'll do that. To go simul 2010. No adjournment.
tomorrow.
Not tomorrow. Today we'll do. We'll simultaneously read the records and. What is why you want to appeal against the bill? What is the case?
Because I have not confirmed.
Okay, go through it.
Because it was similar.
Okay. Against conviction or acquittal? Against acquittal, state has come. Okay,
Item 54.
3 pages will close it. He has suffered enough. Okay,
Item 54.
yes, Mr.
Division of 2022.
After view, after puja, this matters will take up. Okay, though you are for a petitioner, though Mr. Chaudhary is present for the petitioner, however, none appears for the respondent. Accordingly, matter stands adjourned and be listed after answering puja vacation in the hearing column. Interim order, if any, passed earlier. Any interim? Yes. 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 Okay, sir. Assess. We have got a respondent. This matter is under bail hearing or what? AB 2670. Yes, Borua, what is the case diary? Where is the affair? Scan copies call for. Can you please there? Give it to him.
Such that case also, he has been issued some of them.
Okay.
Now, on the second is another is 676. So he is appearing that in the event of his appeal also, he will be put behind.
What about any bail granted during trial? Have you approached? No. There was an affair. During investigation, did you apply for any bail anticipated?
I do not have knowledge that this case is pending against me also. Therefore, I came to know and.
What is your name?
Actually, my name is also Riyadul Haq, Aizul Haq. And the affair object is name as Muhammad Babu Ali.
Usumi.
Only have a look at affair. Case taken is the affair. I have only 20 years object. And she is a married lady object. Case taken is the affair. I am able to appear before the trial court, but already some protection is granted.
What is your name?
My actual name is Aizul Haq. My nickname is Babu Ali. My nickname also FIR has been lost.
You minus 20. You Borua, you minus 20 years from 20 years from age 20. She has 1 year. According to her, she this just live streaming just for time being live stream. Close. Irregular sanction, effective sanction, and so what remains then? If they have done hostile, forget about the other part sanction. How many witnesses were examined? So the seizure itself was not proved that this money was seized, trap was laid, seized. Who is Damboru Core, PW1? Informant. Okay, this is education. What is the name of the accused? Let us first know that. What is the name of the accused? Are you having the copy of the evidences? PW1. So PW1 was the informant. Yes.
I joined in the service in the year 1984.
Mr. Counsel, you take your, will hear you take your seat.
In the year 1987, I was appointed to the system headmaster. I know it was Mohammed India, who is working as headmaster at Nizam Makum LP School. Both the schools are looking to the system of Margarita Circle. In the year 1997, I was working on my team at the relevant time. It was Mohammed India was working as secretary of Nizam Makum Primary Teacher Center. I was working as general secretary for the company. Margarita Circle. At the relevant time, the duty of general secretary was to connect the secretary of teachers from the bank and to distribute the knowledge in the secretary of each circle. I think given the 4,000 rupees on June for converting my group from 10 to 1 to 2. Then I from the letter to NGO to be Margarita, who took the first for the identity loan of 6,000 or 6,000 of 6 in the numbers and up to discuss the matter with LPCO. Accordingly, I told the matter to LPCO, who up me to hand over the case to follow the issue. I was accompanied by Bruno Bunda and me, that is head of Wade Button Action on one laptop wall, the wall. Accordingly, I handed the money to accuse that its own residence that is not a software heading over the country to accuse immediately for the matter to LPCO by the first and accordingly, I think to allow the father to pass to the house of the king and make search about the government to the government position of security. Thereafter, I wrote one chapter against the accused with 20 arguments here. I did one chapter, I did one is my signature. I also go and
Okay, so informant is more or less is there. He said that yes, toss is there. Then who is PW? Two. Hmm.
is the mother one of the witness.
In chief, he says, I was accompanied by one Purna Burua, LD assistant
Yes, sir.
of Niz Makum High School and Lothokor. Where these two persons examined as witnesses? Because they were vital witnesses. Purna Burua and Purna is PW. Lokho is PW6. Okay. Hmm. Purna is PW7, no? And who is this Indresh Dihingya? He is the Caesar witness.
Two, three, four are the players.
Okay, their witnesses are vital.
Here,
Yes.
I joined in the service in the year 1999, PW2 academy as LP school teacher and family LP school, Lomagao graduation on 15/11/97. I was working as LP school teacher in the associate school. On that day, only at first the house semester of body, we have been a father of LP, where I accused was residing in the house. Till now, accused Mohammed India is residing in the house. Accused me of the
First was declared hostile. No, in chief, he has said I was present. This is my signature.
that would say that there is no to condition and get to be processed.
Which one is the cross by the defense, prosecution?
No one will go to court.
Okay, so during cross by defense, he said, I sign, put sign in a blank paper.
You see, my lord, we stated this clear thing.
He has seen, he proved his signature also.
Should be given, he was part of the team. Also,
But why have you declared him hostile? Problem is this. And scope is limited in a case of acquittal. Of course, there is some recent judgment where you can say that we can reappreciate the evidence. But few favorable to the accused, that is settled. Okay, PW3.
because he is my lord, Bobby so now he is also one of the my lord,
Why? After asking 2 lines, was declared hostile. Might be they also knew that he's not going to say much.
the same my lord, statement given to the PWC. So I have put my signature in blank paper.
Who is PW4? He also,
He is also one of the he was
but he also said the same thing.
there are kind of six level application. There is some exchange of
Ammonia. Then PW5. Which one?
PW4
Huh.
at the time of picking the situation on exhibiting recorded blank knowledge regarding the day of trial. Mr. Sinha LPPO organizer came to the place of the trial. Taking Mr. Sinha used to keep the memories of people for distribution payments. On that day, I went to the house of Deputy Mahomet to connect the children of others. At this time, informing those who were the incident of the city. He gave 3 bundles of 10 rupees. He gave 10. He gave 3 bundles of 10 rupees and you he took 30 numbers of 100 rupees currency and I think
That is why I say ammonia. I already read.
but there is some transaction.
That transaction cannot. Then PW5. What is the role? Necessary.
I was looking at them to the party and accommodated. I was in charge of the accommodate and that's according to the so we could against the accused, the dealer of the file to and time, revision time, GIS to
That,
the
that signature notes were also not exhibited. Huh? Not exhibited. How will you prove? To prove that there was a demand. Demand is supposed to through the PW1. Now delivery, he said, I delivered. But the prosecution witnesses has not supported the delivery. Rather, one witness which was not declared hostile says that yes, money was given, 300, and he gave in exchange 10 rupees. Can we say it to be beyond reasonable doubt?
The signature, my lord, not to my lord. That is what down taken. And another one taken, the sanctioning authority is not the competent authority. But at that point of time, we have to not the appointing
Now,
authority.
suppose sanction is there, assuming for a moment we don't go to the sanction is there. But also, it was a offense under PC Act, demand of bribe. Now, what is the purpose of putting the signature in the notes? That this is the money I have given. This is signature is put by the SDP or something like that. Who put? Whether SDP was examined. So notes were not exhibited. The person who signed in this check, he is the main person saying that yes, he lodged a complaint before me. Accordingly, I advise him to do so and so. I put signature on the notes and he gave that note to the person. Accordingly, we seized it from his house. And these are the person witness in before whom we have seized it. Metharens, they are convict him. So suppose assuming for a demand is proved that there was a demand, because one he said demand. Okay, there is no cross-examination, it's okay, demand is fine. But that demand was met, was a trap. And in that trap, there were two witnesses, notes were previously signed, nothing has been proved. So rightly acquitted. Let us not spend 10 years old case too much of time.
He cannot use. There is a repeater presumption also happening. Where data are taken.
He led defense witness. So rebuttal evidence will come at least. What is the foundational fact? You must at least lay the foundational fact. That this is the foundation, this is the demand, this is the delivery, this is the proof. Which one is the SDPO's evidence?
expired.
And he was expired. At the time of marriage.
All half-hearted.
When the based minus two section also regarding the section. And this type of cases where the safety sanction is to the accuser.
Suppose we say that sanction is correct. Okay, let us say sanction is correct. What is the end result? Nothing. Why should we endeavor into that at this stage and passage husband which may affect you also, them also. In appropriate case, we will decide, not in this case.
So those are another statement is the
Hmm.
already another regarding the converting this code from plan to non-plan. It has already been made, but he has realized this as to read to win. That is a part of
Where is the affair? Where is the affair? During the IOS IOS examination, kindly read IOS examination. PW 10.
I joined the police service in again 1976.
Hmm.
As letter of police on 15/10/1992. I was working as a supervisor for the police. I received one letter from the government for against technical and the daily for demanding edited work. 3,000 pounds to convert the post on and after receiving the case of the police station convert on the year. During the course of interview, I went to the extent of experience level with other police persons. And at the other day, some of 300 and 300 of 10 of 1,050. The figure was made in the presence of police officer working on investors of the court. Exhibit 2 is the figure 2, 4 is the figure 9 is the exhibit 2 is the figure 7 is the investors, exhibit 2 is the figure 7 is the income, and exhibit 2 is the figure 7 is the figure of income. Exhibit 1 is the FI, exhibit 1 is the figure 7 is the bonus. Exhibit 1, 2 is the figure 7 is the exhibit 1 is the registration was exhibit 5 is the exhibit 5 1 is
Come to the cross examination. Where have the money gone? Where have the notes gone? Kindly come to the evidence of PW 11. Can go to the cross examination. The fundamental thing that money was given and seized before PW 2, 3, 4,
234 and
2, 3, 4 is not established. There, these are the notes which were signed by the deputy commissioner or SDU, ESC whatsoever, was not even before the court. Rightly acquitted.
and but PW one in safe manner.
Yes.
I have
No, PW1 in CP says there is a demand, PW11, yes.
I have an IS officer 1994 that
No.
so belonging to Assam Technical Center. From December 1996 to June 98, I was working as LPO the whole for and then he has informed the tech to LPO. This is to for
SDO civil said, go, police. And CC, come down. I have already read it. You come down. Yes. Hmm.
He had one input after accused of the crime. So far, I recollect, I put my signature on the basis and the accused was shot 800 along with the crime. Accordingly, police had secured one secret.
Okay. So according to her, she put her signature. She was not present. She had no personal knowledge. Her knowledge is that information was given to her that so and so demanded money. So she signed the signature. Now come to the next page. She'll have to prove the signature. Yes, these are the notes. This is my signature. Notes are not exhibited. Then which money is handed over? Demand must complete, na? Dictation? Heard. Mr. Goswami, learned additional public prosecutor. Also heard Mr. PM Dastidar, learned counsel for the respondent accused. No submission. I am acquitting you. Keep your argument for other cases. I am dismissing their petition. Suppose you argue for 5 minutes, 10 minutes. You take your seat, you keep your energy for the next case. The present appeal under section 378 of the Code of Criminal Procedure is preferred by the state of Assam against the judgment and order dated 14/7/2009 passed by the learned special judge Assam at Guwahati in special case number 3 of 2005, whereby the respondent accused was acquitted from the charge under section 9 of the Prevention of Corruption Act 1988. Full stop. What is the judgment? The learned trial court below acquitted the present appellant basically on 2 counts. Firstly, that the sanction order granted by the employer was defective. And secondly, that the prosecution has failed to prove beyond reasonable doubt that reasonable doubt that the accused demanded bribe and same was given as per demand by the informant PW1. Full stop. Informant PW1. The learned trial court has came to a conclusion that the recovery of the tainted money from the possession of the accused was not proved. Was not proved. Full stop. It was the further findings of the learned court below that the tainted money who was alleged to have been signed by PW11 even were not exhibited, nor the signature put by the PW11 in the tainted money in the trap where signature was also neither exhibited nor proved. Therefore, according to the learned trial court below, the prosecution has failed to establish beyond reasonable doubt that there was demand of bribe and the same demand was made through the trap and the recovery was made. Full stop. Law is by now well settled that more particularly the Honorable Apex Court in the case of Umed Bhai Jadav Bhai versus State of Gujarat reported in 1978 1 SCC 288 held that once an appeal against acquittal is entertained, the High Court is entitled to reappreciate the entire evidence independently and come to its own conclusion. Full stop. Law is equally well settled that while doing so, the appellate court is to give due importance to the decision arrived at by the trial court after proper appreciation of evidence. Full stop. Full stop. Recently, in the case of Guru Datta Pathak versus State of Uttar Pradesh, reported in 2021 6 SCC 166, the Honorable Apex Court, after elaborately discussing different earlier decision of the Honorable Apex Court, Honorable Apex Court laid down the following proposition and principles of law while dealing with an appeal against acquittal. The paragraph 15, such determinations and discussions were made in the paragraph 15 to 20, paragraph 15 to 20, which are quoted herein above. Okay. The section 9, na? Huh. Just the. Oh, sorry, PCA. Yes. Earlier section 9, now it is 7, 7 and 13. That's why I'm trying to have the old act. In fact, there is a recent judgment, there is marked change 2023 in case of corruption, but we are not applying those judgments here because we have no evidence. Had it been some evidence, it's a case of acquittal. Otherwise, I'm searching it. Just give me 5 minutes. It is by now well settled that it is also by now well settled that proof of demand for bribe by a public servant and its acceptance by the official is an essential ingredient for establishing the offense under Section 9 of the Prevention of Corruption Act. Full stop. Thus, proof of demand of bribe by a public servant and its acceptance by him is a sine qua non for establishing the offense under Section 9 of the PC Act. Full stop. In view of the aforesaid settled proposition of law, now let this court examine the present case. The PW1 is the informant who alleged that where is the evidence? Where is the evidence? No? Mustumi, you want to say something? You want to go for a phone, but no, I'm looking to heavy. This is the file. You know, the periphery of the phenomenon of the nature. So that's the way we can statement this file one. No? The PW1 is the informant who deposed before who deposed that at that relevant point of time, the accused was working as a secretary of Niz Makum Primary Teacher Center. And as per norms, he was to collect the salary of teachers from bank and to distribute the salaries to the respective teachers of the said circle. It was also his case that it was also deposed by him that the accused demanded rupees 4,000 from him for converting his post from plan to non-plan scheme. Accordingly, he informed the matter to the SDO Civil within bracket PW SDO Civil Margarita within bracket PW11, who put her signature on the currency notes of rupees 3,000 consisting of 10 rupee currency note of 300 numbers and asked him to discuss the matter with SDPO. Accordingly, the PW1 reported the matter to the SDPO who asked him to hand over the said 3,000 rupees to the accused. According to the informant PW1, he was accompanied by Purno Borua, LD assistant of Niz Makum High School within bracket PW7 and one Loikho Kaur PW6. According to him, he handed over money to the accused in his residence, and after handing over the money, the accused informed the SDPO over phone. And accordingly, SDPO along with other officials reached the house of the accused and made a search in the house and premises and recovered the amount of rupees 3,000 from the possession of the accused. And thereafter, the FIR was lost. Full stop. The PW1 exhibited Exhibit 1 as FIR and Exhibit 1 as his signature. He also testified that in the FIR, PW7 and PW6 are shown as witness to the occurrence. During cross-examination, he deposed that he cannot recall who put the signature in the name of witness Purna Borua. Purna Borua is PW7. He admitted during cross-examination that there was an election to the post of Center Secretary in the year 1997, wherein the petition wherein the informant as well as accused contested the said election and the accused was, the informant was defeated. However, he denied the suggestion that due to such defeat, he has lost the aforesaid affair. Okay. The PW 7, PW 2 is one Indresar Dihinia. And a seizure witness of the seizure of the currency note allegedly signed by the SDO, isn't it? SDO. In his examination in chief, he deposed that Exhibit 2 is the seizure list and Exhibit 2 within bracket 1 is his signature in the seizure list as witness. He further testifies during the course of during his deposition that one Anupam Borua within bracket लिखित हो PW स्वयं and Mohi Pukan within bracket लिखित हो PW were present along with him at the relevant time when the police had searched the house and premises. He proved Exhibit 2 within bracket 2 as the signature of witness Anupam Borua and 2 within bracket 3 as the signature of witness Mohi Pukan. The said witness was declared as hostile at the instance of the prosecution, and the prosecution cross-examined him. He denied the suggestion of the prosecution that he stated before police that during the search of the house and premises of the accused, all formalities of the police were followed and bundles of rupees, as discussed, had been seized. During cross-examination by the defense, he deposed that while putting the signature in the seizure list, the same was a blank paper and nothing was written thereon by the police. He further deposed during cross-examination that he has not seen the police in recovering 3 bundles of 10 rupees currency notes from the house and premises of the accused. Full stop. Thus, this witness during cross-examination testified that he has not seen the seizure of the signed and tainted currency notes, and his signature was taken by police in a blank paper. The PW 3 is another seizure witness who proved the seizure list as Exhibit 2 and his signature as Exhibit 2-3. He was also declared hostile, and during cross-examination, he also stated that his signature was taken in the seizure list in blank paper and he has not seen police seizing the tainted currency notes. PW 4 is another seizure witness. During examination in chief, he deposed that while Exhibit 2, police had seized 3,000 rupees from the house and premises of the accused, and he also proved his signature in the seizure list and also the seizure list as Exhibit 2. However, during the cross by the defense, he deposed that at the time of putting his signature, nothing was written on Exhibit 2 and it was a blank paper. He had no personal knowledge of demand of any money by the accused from the informant. It was further testified that on the date of occurrence, the SDPO Margarita came to the place of occurrence. He also deposed during cross-examination that the accused used to keep the salaries of the teachers for distribution and payment. And interestingly, this prosecution witness during cross-examination deposed that on the day of occurrence, he went to the house of accused to collect the salary of his father. And at the time, the informant came to the residence of the accused and he gave 3 bundles of 10 rupees currency notes to the accused. And in lieu of that, he took 30 numbers of 100 rupees currency notes from the accused by way of exchange. He further deposed during cross-examination that the informant told the accused that he is getting inconvenience in carrying the bundles of 10 rupees currency notes for which he requires 100 rupees currency notes. Full stop. This witness was neither declared hostile by the prosecution nor any cross-examination was done. Further, this witness was also not confronted with his statement recorded under 161 CRPC, as he was not even declared as hostile witnesses. Full stop. The the investigating of the SDPO, investigating officer, has in the meantime expired, and the investigation was continued by PW 5 and PW 6. Their evidences are not very vital for the purpose of determination of the present appeal preferred by the state. The PW 11 is the then SDO Civil Margarita. According to PW 11, the informant approached her and informed that the accused is demanding bribe for change of his post from plan to non-plan. Accordingly, she advised her to visit the SDPO Margarita, and she put her signature in the tainted money. And so far, she recollects the said tainted bribe money was seized. During cross-examination, she submitted that she deposed that she had no personal knowledge regarding demand of money by the accused. She further deposed that in the court, the seized currency notes were not produced. Full stop. After the evidences were over, well, who is CW1? After the prosecution witnesses were over, the accused was examined under section 313, na? 313. 313, and he denied the allegation and the incriminating material put against him, pushed up and examined one witness, Purneswar Gogoi as DW1. The said DW1 is the block elementary education officer of Margherita. He exhibited one document to prove that the post held by the informant is a permanent post and prove the same as Exhibit A in original. Whose post? This was post held by the informant. That PW, DW1. Post official, held by the informant, not by the accused. Informant. That it is conversion of plain and non-plain. To prove that the post held by the informant was a permanent post, and accordingly, when? And he further deposed that on 1/3/1997, the post of the informant was converted from plain to non-plain. I have seen that. During cross-examination, he deposed that his immediate boss is district elementary education officer. And while coming for deposition, he has not taken written permission from the his superior officer. His examination is not relevant for determination of an offense under section 9 of the Prevention of Corruption Act. Another witness was examined as fourth witness, namely Sri Shiva Prasad Moran, an ASI of police. He deposed that his duty was to look after the police station Malkhana and also to perform law and order duty as and when entrusted by the superior officer. He took over charge of the Malkhana on 28th of April. And he did not receive MR number 62/97, which relates to the Margherita PS case number 142/97 from his predecessor, Mr. Prafullo Kumar Saikia, ASI. Full stop. He further deposed that he had received only 2 items from the year 1997, namely MR number 30/97 and MR number 37/97, which relates to other cases. MR number 62/97 relates to 3 bundles of 10 rupees notes consisting of 1,000 rupees in each, totaling 3,000 only, which were not found available in the police station Malkhana. He proved Exhibit 6 as the list of pending MRs material. What MRs mean? What's the MR? Malkhana register MRs of Margherita police station, which has been certified to be true by the SDPO Margherita. Full stop. Thus, from the aforesaid, it is seen that though the informant has specifically stated that a demand for bribe for converting his post from plan to non-plan was made by the accused, and accordingly he satisfied such satisfied the demand, and a trap was laid, and the money paid by the informant as bribe money / tainted money was recovered from possession of the accused. However, the witnesses, according to the prosecution, before whom such tainted money was recovered, was not proved, inasmuch as all the witnesses of such seizure has deposed that they have not seen the seizure, and their signature were taken by police in blank papers. One seizure witness, as discussed herein above, though admitted that the accused handed over the money to the informant handed over the money to the accused. However, accused returned him 100 rupees net in exchange, and the informant requested for such exchange as it is difficult to carry 100 rupees, 10 rupees or 10 rupees notes. Such witness was not even declared hostile by the prosecution or was cross-examined. In view of the aforesaid, the finding of the learned Sessions Court cannot be said to be a perverse finding, inasmuch as this court is in total agreement with the finding of the learned Sessions Judge that the prosecution has been failed beyond reasonable doubt that there was demand of bribe, and the same was made by the accused. Therefore, this court finds no substantial or compelling reason, and good or sufficient grounds, or any circumstances, not to say very strong circumstances, to interfere with the decision rendered by the learned Sessions Court below. Accordingly, the present appeal preferred by the state stands dismissed. The LCR be returned back. At least 2010 matter one is over.
he has denied this.
Okay, I did not. Okay, okay. Yes, sir. Such suggestion, about such suggestion that it was converted in the year 96 itself, 97 itself was denied by this witness. PW 1. That was anything left? All failure, these police officers are there. All are acquitted because of the faulty investigation or faulty investigations. I'll tell you one thing. We have not taken a decision. That case, what was that? Last was there. Investigations are not properly done. That proof that money, tainted money was not even exhibited. Lost means what? It's a fault of investigator. It was lost. The officer was called in, the SDO, IS officer, who put her signature. That was not exhibited. There was no reliable people. Everybody became hostile. What to do? Even if it was demanded, we cannot acquit him. We cannot convict him. Done.
Thank you.